1 start. When a criminal court and a court martial have each jurisdiction in respect of an offence, then it shall be in the discretion of the chief of the air staff or the commanding officer of any group, wing, or station to decide before which court the proceedings shall be instituted, and if that officer decides that they should be instituted a court martial, then he has to direct that the accused person shall be detained in Air Force custody. As per Section 124 of the Air Force Act, the commanding officer has the jurisdiction to try offences relating to civil offences. Criminal court or police can only assume jurisdiction to try offences only after giving a written notice to the concerned authority of the Air Force. If any offence is committed against a person who is also subject of the Army, Navy, and Air Force, then the court martial has to be exercised. In the present case, petitioner is also a subject of Air Force, and hence the court martial has the jurisdiction to try the present matter. Honorable High Court has stated that though the system of court martial appears to be an in-house mechanism, proceedings before the court martial are not mere disciplinary proceedings, but they are akin to criminal proceedings before a regular criminal court, and hence it has been given with the power of a sessions judge. Once an option under Section 124 is exercised, there is no necessity to continue or complete investigation by the police, and hence an order should be passed that the police shall not continue the investigation unless it is expressly desired by the competent authority. In the present case, the competent authority has undertaken the investigation, and after considering the facts and the witnesses, it has come to a conclusion, and therefore the police investigation is not required. It is further stated in the objections that upon the receipt of the complaint, the FIR came to be registered, and in view of the sensitivity of the case, a special investigation team was constituted and entrusted with the investigation of the case, and during the course of investigation, the petitioner has been found involved in the heinous crime, and that the petitioner is trying to mislead the court by referring to the provisions of sections 71, 72, and 124 of the Air Force Act 1950. Upon taking up the investigation in the matter by the police, the statement of the answering respondent came to be recorded before a magistrate by the investigating agency in terms of Section 183 of BNSS 2023, and that the offence committed by the petitioner was initially confided in two lady officers immediately upon its commission by the respondent, and that the proceedings were cancelled only after 2 days of its commencement on account of gross lapse in the procedure, and another inquiry was undertaken by the internal committee upon a fresh application filed by the answering respondent herein, and the said internal committee opined that the occurrence of the alleged incident cannot be confirmed. Representation was not considered, and instead of this, complete lack of propriety came to be shown by the internal committee during the conduct of its proceedings. In addition thereto, Mr. Shah would also urge the application of the provisions of Section 124 of the Air Force Act 1950 to the matter, and would seek transfer of the investigation in the FIR under challenge along with the instant matter to the jurisdiction of the authorities under the Air Force Act 1950. The gist of the arguments put forth by Mr. Shah is that In view of the findings recorded by the court and internal committee in the matter, the registration of the impugned FIR is an abuse of process of court and thus it needs to be quashed in order to secure the ends of justice. The said report was actuated with malafide as the conduct of the respondent was such so as to make her liable to disciplinary action. It is pertinent to note here that while considering the instant matter at its threshold, this court directed that the investigation shall continue pursuant to the impugned report. However, the charge sheet shall not be filed. As has been noticed in the preceding para, the police has conducted investigation and perusal of the case diary tends to show that same seems to be nearing completion. Before proceeding further in the matter for the purpose of rendering a decision on the merits of the case, it would be appropriate and profitable to discuss the ambit and scope of the inherent power vested in this court under section 582 of भारतीय नागरिक सुरक्षा संहिता. स्टॉप. ये 125 पे